Imagine winning a massive, just a sprawling 5-year lawsuit against a multi-billion-dollar corporation.
Right.
You actually prove in a court of law that they misclassified you, that they broke the rules, and you were standing there waiting for justice to finally be served.
It's the moment you've been fighting for.
Exactly.
Yeah.
And the jury awards, you get this, exactly $0.
Ouch. Yeah, that's a tough pill to swallow.
It's wild. Now hold that thought, and imagine a millionaire driving a spray-painted burner minivan into a corporate parking garage to commit a premeditated murder.
Completely different scenario.
Oh, completely. But then after the murder, his insurance company essentially foots the bill for the aftermath of his crimes.
Yeah, it sounds like fiction, but it's not.
It's not. Welcome to today's Deep Dive.
Oh, yeah.
Today, we're looking at two entirely different legal cases that share this bizarre, almost unbelievable coincidence.
Right, the connections are uncanny.
Both cases hinge on a man named Milner.
Which is just a coincidence, to be clear.
Yeah, purely a coincidence. And both cases intimately involve the corporate entity Farmers Insurance.
Also wild.
And both cases expose these fascinating, frustrating, and honestly, sometimes tragic loopholes within the American justice system.
Yeah, it's essential to state right at the top that the connection of the names, Gary Milner in our first case and Stephen Milner in our second, there's no familial relation there.
Right, no relation at all.
But the real connective tissue here, the reason we are exploring both of these really dense source files with you today is how they illustrate the sheer mechanics of the law.
The gears of the system.
Exactly. We are looking at what happens when the rigid, literal text of statutory law collides with the deeply messy reality of human behavior.
That is exactly what struck me when reading through this huge stack of sources we have today. We've got news articles, trial records, police transcripts, and this incredibly dense 2008 Minnesota Supreme Court ruling.
Oh, yeah, it's a lot of reading.
It is. And we often expect the legal system to act like this precision instrument,
Yeah.
Like you enter a courtroom, the facts are presented, the judge points to the statute, and justice is just dispensed logically.
A nice, clean equation.
Right. But the deeper you read into these files, the more you realize that this precision is sometimes a total illusion.
It really is.
The system is a machine that relies entirely on victims to carry this immense burden of proof, whether you are fighting a corporate giant or, as we'll see, a lethal stalker.
Well, let's start unpacking this by stepping into the world of corporate labor law.
Let's do it.
We are looking at the 2008 Minnesota Supreme Court case, Gary J. Milner et al. Versus Farmers Insurance Exchange.
Okay, lay it out for us.
So this case truly operates as a masterclass in the technicalities and really the rigid boundaries of labor law. The setup is this: Gary Milner, alongside a group of fellow claims representatives, brought a multi-count class action lawsuit against their employer, Farmers Insurance.
And a class action is no small thing.
Not at all. The absolute core of their argument rested on the claim that they were misclassified as exempt employees under the Minnesota Fair Labor Standards Act.
Which is often abbreviated as the MFLSA in the documents.
Right.
And for anyone who hasn't spent time wading through the swamp of employment statutes, the distinction between being an exempt and non-exempt employee is massive.
It changes everything about your paycheck.
It really does. If you are exempt, it basically means the company is legally off the hook for paying you overtime.
Because you're considered an administrative, executive, or professional employee.
Right. You get a salary, and whether it takes you 40 hours to do your job or 80 hours to do your job, your paycheck remains exactly identical.
Precisely. And the historical context of that distinction is really important for understanding why this lawsuit even happened.
Where does it come from?
Well, the concept of exempt versus non-exempt dates back to the Federal Fair Labor Standards Act of 1938.
So, Great Depression era stuff.
Yeah. The idea was to protect factory workers and laborers, the people doing the physical grind, from being overworked without fair compensation.
Which makes sense.
But lawmakers decided that high-level managers, executives, or specialized professionals who had broad autonomy and decision-making power, well, they didn't need those same hourly protections.
Because they're calling the shots.
Exactly. They were compensated for their expertise, not just their time on a clock.
Which makes sense in theory, right? Like if you're the CEO, you aren't punching a time card.
You're not clocking out at 5 p.m.
Right. But in practice, companies quickly realized that if they could just stretch the definition of administrative professional to include lower-level, desk-bound workers, they could legally demand unlimited hours for a flat rate.
And that is exactly what the plaintiffs in this Minnesota case argued was happening to them.
Because these were insurance claims adjusters.
Claims
Right.
representatives, yeah.
Yeah.
They argued that their actual day-to-day job duties did not fit the legal definition of a bona fide administrative capacity.
They weren't executives.
Right. They weren't setting company policy. They weren't exercising broad independent judgment on matters of significance.
So what were they doing?
They were essentially working a white-collar grind. They were handed a stack of insurance claims, given a strict set of company parameters on how to process them, and just told to get it done.
Like an assembly line, but with paperwork.
Exactly. And to keep up with the workload, they argued they were routinely putting in well over 48 hours a week.
Which is the specific overtime threshold under Minnesota state law.
Correct. And they weren't getting paid a single dime of overtime for those extra hours.
So they take this to court. And this isn't some quick settlement.
No, this goes to a massive 10-day jury trial in Hennepin County.
I want to pause and just think about the sheer resources required for a 10-day civil trial against an insurance giant.
Millions of dollars in legal time.
Yeah. The plaintiff's lawyers are calling witnesses, bringing in experts to analyze job duties, dissecting the employee handbook line by line.
It's exhausting.
And the jury sits there for 2 weeks listening to exhaustive testimony about exactly what a claims rep does all day.
Riveting stuff, I'm sure.
Oh, I bet. And finally, the jury is handed a special verdict form. They deliberate, and they hand down a verdict that is basically a split decision, but in the most structurally bizarre way possible.
It really is bizarre.
The jury actually agrees with the employees.
Hmm.
On the special verdict form, they check the box that says, no, these claims reps do not regularly exercise independent judgment or administrative duties. They are misclassified.
Which is a phenomenal victory for the plaintiffs on paper.
Huge.
I mean, overcoming that hurdle against a well-resourced corporate defense team is incredibly difficult. They successfully proved the misclassification. They proved Farmers Insurance was wrong to deny them overtime protections.
But this is where the precision machinery of the legal system creates a truly absurd outcome.
Because of the next question.
Yes. The very next question on that special verdict form asks the jury, what amount of money will adequately and fairly compensate the plaintiffs for unpaid overtime hours worked over 48 hours per week?
And the jury writes down
$0.
Zero. It is the ultimate hollow victory.
I can't.
Winning the legal battle on principle, but completely losing the war for actual, tangible restitution.
I am still trying to wrap my head around how that functionally happens in a courtroom.
It comes down to proof.
But if the jury literally just agreed that you were wrongly denied overtime pay for years, how do they arrive at $0 in compensation?
Well, this brings up your absolute biggest frustration when reading through this source material.
Yes. Farmers Insurance flat out admitted in court that they didn't keep any time records for these employees. None.
Because farmers consider them exempt.
Right. So they didn't track their start times, their end times, or their weekend hours.
There was no paper trail of the hours.
So the burden of proof is on the employees to prove exactly how many hours of overtime they worked over a multi-year period. But the company failed to keep the very records that would prove it.
It's a complete paradox.
It's exactly like a teacher giving you a 0 on a final exam because the teacher lost your Scantron sheet. How is the employee punished for the employer's missing records?
It's an incredibly frustrating catch-22, and your Scantron analogy is spot on. This highlights a massive structural vulnerability in how civil litigation works.
How so?
If we connect this to the broader mechanics of a civil trial, the burden of proof remains strictly, unyieldingly on the plaintiff to prove damages.
The plaintiff has to prove the math.
Exactly. It is a fundamental tenet of our legal system that you cannot simply guess at financial harm. You have to prove not just that a wrong occurred, which they did with the misclassification,
Right.
but you must prove the specific, quantifiable financial impact of that wrong with reasonable certainty.
But if the records don't exist because the defendant didn't keep them, how do you achieve reasonable certainty?
Well, you are forced to rely on secondary evidence.
Which is what?
Without the company's time cards or login data, the plaintiffs had to rely on their own estimates, personal calendars, memories, and expert witnesses who tried to extrapolate average working hours based on caseloads.
So they're just guessing based on how many files they closed.
Essentially, yeah. They had to get on the stand and say, well, usually on Tuesdays, I stayed until 7 p.m., and I worked roughly 3 hours most weekends.
And the defense lawyers just tear that apart.
Of course. The defense attorneys are highly skilled at poking holes in human memory. They will ask, "Are you sure you didn't leave early for a doctor's appointment on March 14th, 3 years ago?
Oh, man.
Are you sure you were working and not chatting at the water cooler?"
Right. Cast doubt on everything.
And the jury clearly felt that while the legal classification was wrong, the plaintiffs simply hadn't met the high evidentiary burden to prove a specific, mathematically sound dollar amount of unpaid time.
Because it wasn't exact.
Right. The jury couldn't just invent a number out of thin air, so they wrote 0.
Which feels entirely backwards to me. Think about the incentive structure here.
It rewards bad behavior.
It does. The company violates the law that requires them to keep accurate payroll records. And because they broke that record-keeping law, they successfully obscure the evidence.
Making it impossible to prove damages.
Exactly. Which means they benefit by not having to pay out the millions in overtime damages. It actively rewards corporate negligence.
It's a huge loophole.
Thankfully, reading further into the case, the trial judge seemed to recognize the sheer absurdity of this outcome.
Yes, the district court judge essentially staged a judicial rebellion against the $0 verdict.
I love this part.
Seeing the inherent unfairness of a corporation benefiting from its own failure to keep records, the judge decided to exercise what's called equitable relief.
What does that mean?
The judge looked at the statutory penalties for failing to keep records and hit farmers' insurance hard. The judge imposed a civil penalty of $500 per person per pay period for the duration of the violation.
That's a lot of pay periods.
It is. That calculated out to $376,000.
Okay, so that's something. And the judge didn't stop there. He also addressed the massive legal bills the employees racked up over 5 years.
Correct. The judge awarded the plaintiffs $1.8 million in attorney fees.
Wow.
And to do this, the judge used something called the lodestar method, which calculates the reasonable hours worked multiplied by a reasonable hourly rate, but then the judge applied a 1.5 multiplier to that base amount.
A multiplier. Why do that?
This is a crucial mechanism in civil law. Multipliers are used to reward lawyers for taking on highly complex, risky cases on contingency.
Because if they lose, they get nothing.
Exactly. It's a way for the court to say, look, we need private attorneys to enforce these labor laws against big corporations, so we will financially incentivize you to take these tough cases.
So the trial judge basically looked at farmers and said, you didn't keep records, you misclassified your workers, you created this evidentiary black hole, so you were going to pay for it anyway.
Right.
It felt like a moment of actual common sense prevailing.
It did feel like that for a minute.
But, well, of course, that is not where the story ends in our sources. Farmers insurance has deep pockets.
Very deep.
They appealed the trial judge's penalties, and the case climbed all the way up to the Minnesota Supreme Court.
And this is exactly where the cold, mechanical nature of statutory interpretation truly reveals itself.
It's infuriating.
The Supreme Court reversed much of the district court's rebellion. They didn't rule on what was fair, or just in a philosophical sense.
Don't care about the Scantron analogy.
Not at all. They ruled on a very specific, almost surgical technicality within the text of the statute. They stated that misclassification itself is not actually a violation of the MFLSA.
Wait. I remember stopping and reading that paragraph in the source file like 3 times.
It's dense.
How is misclassifying an employee, which directly denies them overtime, not a violation of the employment law? That sounds like semantic gymnastics.
It is semantic, but in the law, semantics are everything. This delves into a legal philosophy known as textualism.
Textualism.
Right. Textualist judges look strictly at the words on the page of the statute, not the broad intent behind the law.
Just the literal word.
The Supreme Court noted that the section of the MFLSA defining an exempt employee is just a definition section.
It just defines a term.
Exactly. It doesn't contain an affirmative command. It doesn't explicitly state an employer shall not incorrectly classify an employee.
Oh, come on.
It just defines the terms. So the act of misclassification, standing entirely alone, isn't an actionable violation because there is no verb in the statute forbidding it.
No verb.
But however, the statute does explicitly state an employer must keep time records.
Ah, there's command.
Yes. So failing to keep the records is a direct violation of a statutory command.
Okay, let me make sure I am following the logic of the court here.
Go ahead.
The Supreme Court says, fine, the misclassification isn't technically a penalty-inducing violation, but the record-keeping failure is explicitly written as a violation.
Yes.
Therefore, the $376,000 penalty for not keeping records stands.
It does.
But wait, if I keep reading the decision, They pull the rug out from under the employees again.
Yes, they do. And this is perhaps the most crushing blow in the ruling. The Supreme Court looked at who actually gets to collect that $376,000 penalty.
And it's not the employees.
No. They ruled that under the strict language of the MFLSA, and they arrived at this by comparing it to another law, the Minnesota Payment of Wages Act.
Okay.
They said civil penalties for record-keeping violations do not go to the aggrieved employees.
Why? I mean, who else would they go to?
Because the MFLSA doesn't explicitly state that the money goes to the workers. Other statutes have specific language saying penalties are payable to the aggrieved party.
But this one didn't.
The MFLSA lacked that specific phrase. Therefore, applying strict textualism, the Supreme Court ruled the $376,000 penalty must be paid directly to the state of Minnesota, not the claims reps.
Wait, if the law says you must keep records and the employer doesn't, how is the penalty just given to the state?
Because it's a regulatory fine.
But the state didn't work 60-hour weeks without overtime. The state didn't spend 5 years in litigation fighting farmers' insurance. That defies basic restitution. The employees who live through all this get nothing from the penalty.
Absolutely nothing.
That is insane.
The logic is that the penalty is a fine for violating state regulations, not compensation for the individual's labor.
Just a fine to the government.
Right. And to add insult to injury, the Supreme Court then targeted the trial judge's award of $1.8 million in attorney fees.
Of course they did.
They ruled that because the plaintiffs ultimately recovered $0 for themselves in compensatory damages, their degree of success in the lawsuit was severely limited.
I mean, they proved they were misclassified.
But you can't claim a massive victory if your clients get $0 in the end.
Wow.
Therefore, the Supreme Court ruled that the attorneys did not deserve that 1.5 multiplier, and the base fees had to be recalculated heavily downward.
So, if we pull back and look at what this all means, the legal machine functioned exactly as it was programmed to function.
Flawlessly, in a mechanical sense.
Right. The text of the statute was upheld to the literal letter. The definition of an employee was analyzed. The burden of proof was strictly maintained.
Everything by the book.
But the human element, the actual workers who spent half a decade fighting a massive corporation to prove they were wronged, they walked away with empty pockets.
It's a harsh reality.
The system was perfectly precise, but it was utterly sterile. It operated entirely in a vacuum, blind to the practical reality that it was demanding an impossible burden of proof from the victims.
It perfectly demonstrates that the law, particularly at the appellate level, is rarely about generalized concepts of fairness or common sense.
It's not about what's right.
No, it is an exercise in structural logic. It is about the literal text on the page and the rigid allocation of responsibility.
Now, I want you to keep that sterile mechanical courtroom in your mind.
Hold that thought.
Hold on to that concept of a system that blindly requires victims to carry an impossible burden of proof against a much more powerful adversary.
Because we're going to see it again.
Because our second source file shows what happens when that exact same legal machine is tasked not with organizing corporate overtime metrics, but with protecting a human life from a relentless, obsessive threat.
A completely different arena.
Enter the other Milner.
Yes. The shift in our sources takes us from a sterile boardroom dispute in Minnesota to a deeply personal, complex, and ultimately tragic saga in Oregon City, Oregon.
Just hard pivot.
It is. And the contrast in how the law is applied, or, well, fails to be applied, is staggering.
Let's introduce the central figure here, Dr. Stephen Neil Milner.
The town vet.
Right, to the outside world, this guy was the quintessential, gentle town veterinarian. He had decades of practice in Oregon City.
A local fixture.
People brought their sick golden retrievers and injured cats to him. He was a pillar of the community, the kind of guy who made local news videos rolling around on the floor with puppies to promote pet adoptions.
A perfect facade.
But the deeper you dig into the financial and investigative records within our sources, a starkly different private reality emerges.
Oh, please.
Stephen Milner was not just some small-town vet scraping by. He was a millionaire.
He had a lot of resources.
He had highly diverse, incredibly lucrative assets. And the most prominent of these was an OLCC-licensed Tier 2 indoor cannabis production facility located in Beaver Creek, Oregon, operating under the name Excolo Farms.
The farm is a huge detail.
I found the inclusion of the cannabis farm in the police reports fascinating because it really paints a picture of his capabilities.
It's not a small hobby, Groma.
No, this wasn't some guy with a few plants in his garage. The state of Oregon categorizes Tier 2 indoor facilities as having up to 10,000 square feet of canopy.
That's a massive operation.
The sources note this facility was producing 20 to 30 pounds of high-grade cannabis flower every single month.
Which requires serious management.
Exactly. To run a facility like that, you have to manage strict climate controls, navigate complex state regulations, manage employees, and handle significant logistics.
It shows a high degree of organizational capability.
Right. He is a methodical, detail-oriented businessman.
Exactly. It establishes that Milner possesses massive financial resources, but more importantly, he has a sophisticated analytical mind accustomed to overseeing complex operations.
He's not just a bumbling guy.
No, he is a man used to being in control of his environment.
And that control is key to what happens next.
It is. But the catalyst for the entire tragedy begins in early 2017, and it involves a complete loss of that control.
It begins with an affair.
Yes. Milner, who was married, was having a secret relationship with his longtime veterinary technician, a woman named Kenneth Fandrich.
And Tanya was married as well.
Right. Tanya was married to a man named Kenneth Fandrich, who went by Kenny. He worked as a contract pipe fitter over at the sprawling Intel campus in Hillsboro.
The psychology of the affair itself, as detailed in the later civil filings, is highly revealing of Milner's intense need for compartmentalization.
It's very strange.
He didn't just have a relationship with Tanya, he created a whole secret persona for her. He gave her the pseudonym Kiki Essex.
Which is the classic first pet and childhood street name combination.
Right, like what you use for password security.
Yeah, but applying it to a human being you are involved with is deeply manipulative.
It's so weirdly controlling. It's like he's trying to overwrite her identity.
It is an attempt to weave himself into the fabric of her identity, controlling how she existed within the context of their secret world.
When she was Kiki, she belonged to him.
She belonged to his constructed reality. But that carefully constructed secret world violently collided with actual reality in July of 2017.
The wedding incident.
Yes, the sources detail an incident at a summer wedding.
Several employees from the vet clinic were in attendance. Tanya and Milner had been drinking, and they started acting very intimate, completely out in the open, which was highly uncharacteristic for them.
They got sloppy.
Tanya had been under the impression that her husband, Kenny, was out of town for a pipe fitting job.
But he wasn't.
Right. When she finally left the wedding and went back to Milner's house later that night, Kenny was there waiting. He had discovered the affair.
Notably, the police reports and witness statements indicate that Kenny did not cause a violent physical scene at the house.
Which is important context.
It is. He confronted the situation, left the premises, and started making phone calls to piece together exactly what was happening and for how long.
He was gathering facts.
But the sudden exposure of the affair broke the psychological spell of the secret relationship. Tanya ended the relationship with Milner shortly after that night.
And that rejection is the primary trigger for everything that follows.
It's the inciting incident.
Tanya ends it. She chooses her marriage. And Milner responds by launching what the civil lawsuits later described as a 4-year psychotic campaign of harassment.
A nightmare.
But here's where I am really struggling with the psychology of this case, and I want to push back on the typical narrative here.
Okay, what's the hang-up?
Usually, if someone is dumped, their anger and harassment are directed at the person who dumped them.
Right, the ex-partner.
If Tanya is the one who ended the relationship, why does Milner spend the next 4 years obsessively targeting the husband, Kenny?
Yeah.
What is the psychological mechanism at work there?
It is a phenomenal question, and it speaks to a textbook yet highly extreme example of a specific stalker profile heavily laced with narcissistic personality disorder.
Narcissism is at the core.
What we are seeing here is the destructive power of the hero complex, or the white knight syndrome.
How did that work?
Milner, as a wealthy, highly respected doctor and business owner, was completely unaccustomed to being out of control.
And even less accustomed to being told no.
Exactly. His fragile ego simply could not process the reality that Tanya would willingly evaluate a blue-collar pipe fitter, and choose the pipe fitter.
He couldn't accept it.
So his psyche had to fabricate an alternative delusional reality to protect his ego from the injury of rejection.
I see. He couldn't be the flawed guy who got dumped because he just wasn't good enough.
No, that would shatter his self-image.
So Kenny had to be a monster, keeping Tanya hostage against her will.
Exactly. Milner convinced himself and tried to convince everyone else that Kenny was an abusive, alcoholic tyrant.
Painting him as the villain.
And that Tanya was a helpless victim suffering from battered woman syndrome. In Milner's constructed reality, he wasn't a rejected lover. He was the noble white knight whose moral duty it was to save Tanya from this monster.
That's a dangerous delusion.
But the truly insidious part, the part that moves this from delusion to active psychological warfare, is that Milner deliberately engineered the very chaos he claimed to be rescuing her from.
The source files are full of these deeply unsettling examples of his tactics.
He was relentless.
He wasn't just observing them. He was actively trying to destroy their marriage from the shadows.
What'd he do?
The documents detail how he would sneak onto their property at night to plant condoms in the Fandrich's vehicles, hoping the other spouse would find them and suspect cheating.
Just trying to create suspicion.
He sent anonymous hate mail to their house. He made relentless, harassing phone calls, just hanging up when they answered.
He was inducing chronic marital discord. He intentionally created an environment of intense paranoia and arguments between Tanya and Kenny.
And it worked, to a degree.
And when those arguments inevitably occurred under the sheer weight of the stress, Milner used the fallout as proof that Tanya was in an unstable environment and needed him to intervene.
It's an incredibly sophisticated form of gaslighting.
It is.
Aimed not just at one person, but at the structural integrity of a marriage itself.
And it led to this incredibly bizarre, terrifying incident in August of 2021.
Oh, this part is crazy.
Tanya and Kenny have a massive fight, which, as you said, is almost certainly fueled by the constant grinding stress of this 4-year stalking campaign.
It has to be.
And the police are called. Tanya actually gets arrested for domestic violence.
Now, the charges were later dismissed, but she is booked into the Clackamas County Jail, and her bail is set at $25,000.
It's the middle of the night.
She finally walks out of the jail doors, and who is sitting right there in the parking lot having just posted a $25,000 cash bail?
Stephen Milner.
Stephen Milner.
And due to the chaotic nature of the arrest and her vulnerable state, she actually ended up staying with him at his house for a few days before reconciling with Kenny and returning home.
But the detail that stops me in my tracks is, how did he even know she was arrested that night? The fight happened inside their private home.
That is the crucial element of terror in this dynamic. It projects an aura of terrifying omnipotence that high-resource stalkers rely upon.
Like he's a god watching them.
Whether he was obsessively monitoring encrypted police scanners, whether he had placed a tracking device on her phone or car, or whether he was actually paying someone within the system for information.
The exact method almost doesn't matter.
It doesn't. The psychological message he was sending to Tanya was crystal clear. I see everything you do. I am everywhere. And when your world falls apart, I am the only one with the resources to bail you out.
It was a desperate, highly orchestrated attempt to validate his savior delusion and force her into a position of dependency.
But Kenny wasn't just sitting back and letting this psychological warfare happen.
No, he fought back.
He was actively fighting back, using the very legal system we discussed in our first case.
And this brings us to a really disturbing theme in the source files: institutional failure and the halo effect.
The system really let them down.
Kenny filed for protective orders. He went to the civil courts. He even filed a $245,000 civil lawsuit against Milner for threats and intentional infliction of emotional distress.
He was trying to use the law.
And in the text of that lawsuit, he quotes Milner making a highly specific, chilling threat.
This is hard to read.
Milner allegedly told Kenny, "I'm a veterinarian. I've done surgeries and I have the tools to chop you up into little pieces."
Just horrifying.
That is not a vague insult. That is a specific, graphic death threat from a man who literally wields a scalpel for a living.
And yet, when you look at the timeline in the sources, the legal and law enforcement response to these escalating threats was shockingly inadequate.
Why didn't they do more?
The sources provide a scathing victim impact statement that Tanya delivered much later at sentencing. She didn't hold back.
She let them have it.
She directly accused the Clackamas County Sheriff's Office of treating her and Kenny with deep indifference and institutional bias.
Because they were just working-class folks.
She stated on the record that law enforcement consistently treated the victims like they were the instigators of neighborhood drama, rather than victims of a targeted stalking campaign.
She specifically named a deputy in her statement, Deputy Steve Wilcock.
Yes, she did.
She alleged that Wilcock spent long hours just casually hanging out, chatting and drinking coffee in Milner's veterinary clinic.
They were buddies.
And in this bitter twist of irony, Wilcock was the specific deputy assigned by the department to serve Milner with the restraining order.
It's absurd.
How does a department allow a deputy to serve a restraining order on his own buddy?
This is a classic, deeply ingrained demonstration of what sociologists and criminologists call the halo effect operating within a community.
The halo effect.
Cognitive bias is a powerful force. Milner's socioeconomic status, the fact that he was a millionaire, a doctor, an established business owner, and his prominent community standing created an informal, nearly impenetrable immunity shield.
He was untouchable.
Law enforcement officials, many of whom likely brought their own police canines or family pets to his clinic for care, simply could not reconcile the image of the friendly, gentle vet they knew with the dark reality of a psychotic stalker described by the Fandrichs.
It's the ultimate blind spot. A cop thinks, oh, Dr. Steve, the guy who saved my golden retriever from Parvo last year. You wouldn't chop a guy into pieces. He's a good guy. This is probably just a messy breakup, and the husband is exaggerating.
Precisely. When you have wealth and social capital, the system instinctively affords you the benefit of the doubt.
The gears of the legal machine slow down.
But for Kenny Fandrich, a blue-collar pipefitter without that social capital, the burden of proof to get the system to act was rendered impossibly high.
Just like the claims reps in Minnesota.
Exactly. Even after a formal stalking protective order, or SPO, was finally issued by a judge in March of 2022, Milner flagrantly continued to violate it.
He didn't care.
He was even put on conditional release for criminal stalking charges, and he continued to breach the proximity limits without facing immediate incarceration.
I have to say, looking at how useless that SPO was, a standard restraining order feels incredibly flimsy.
It's just paper.
It's like putting up a keep off the grass sign to stop a guy driving a bulldozer. It relies entirely on the honor system of a dishonorable person.
That's a great way to put it.
It assumes the violator respects the authority of the court. And if you are dealing with a wealthy narcissist who thinks he is above the law, it is literally just a piece of paper.
Tanya called it exactly that in her victim impact statement, a worthless piece of paper.
Which is why this specific case has become a major flashpoint for discussions about legislative reform regarding domestic violence and stalking.
The laws need to change.
As the sources note, victim advocates have long argued that standard protective orders often serve only to escalate a determined stalker's behavior.
By drawing a legal line in the sand, it provides a clear boundary for the stalker to violently cross to prove their dominance.
The proposed reform mentioned in the files is the implementation of mandatory GPS ankle monitors for individuals charged with violating an SPO.
That would be a game changer.
How would that functionally change the dynamic?
It fundamentally shifts the burden of vigilance. Currently, the burden is on the victim.
The victim has to watch their own back.
Right. The victim has to constantly look over their shoulder, spot the stalker, document the violation, and try to convince the police to act.
With missing time cards, basically.
Exactly. With GPS legislation, the monitor provides real-time geographic data. If the stalker breaches the mathematical proximity limit set by the judge, an automated alert is sent directly to the victim's phone and simultaneously to law enforcement dispatch.
It removes the human bias from the equation.
It shifts the burden away from the terrified victim and places it onto impartial technology and the state.
If Kenny Fandrich's phone had buzzed with a GPS alert every time Milner crossed into his zip code, he might still be alive today.
He very well might be.
Because what happens next in the timeline is terrifying. As we move into late 2022 and January of 2023, the stalking behavior shifts drastically.
It escalates.
It moves from harassment and psychological games to what looks like paramilitary planning.
Milner realizes that his primary vehicle, a highly visible white Toyota SUV, is too well known to Kenny, Tanya, and the local police patrols.
It's a liability.
So he adapts his methodology. He initiates what law enforcement investigators later characterize as a premeditated operational sequence.
He starts utilizing a sophisticated burner car strategy to achieve vehicular anonymity.
And this is where his organizational skills from running the cannabis farm seem to bleed into his stalking.
He goes on Craigslist in October 2022, paying cash, and buys an unremarkable blue sedan.
Just a normal car.
And he doesn't just drive it, he spray paints the entire car black to disguise its original color from traffic cameras.
To avoid automated detection.
Then, in early January 2023, he goes a step further. He buys a maroon Dodge minivan, and he actually uses a false identity, a fake name, to complete the purchase.
But having burner cars creates a logistical problem.
Right. Where do you put them?
He couldn't park them at his house or his veterinary clinic, or they would be linked back to him. He needed a secure, anonymous staging ground to swap these vehicles without drawing attention.
So where did he go?
He chose a local Home Depot parking lot in Oregon City.
It was brilliant in a dark way, high-foot traffic, transient parking, completely anonymous.
His routine became methodical. He would drive his personal white Toyota SUV to the Home Depot, park it in a sea of other cars, and get into one of the untraceable burner cars to make the 45-minute drive out to Hillsborough to stalk Kenny at the Intel campus.
And the level of advanced planning is chilling. I want to highlight a specific date from the sources, December 13th, 2022.
The rehearsal.
That is a full month before the murder. Milner goes to that same Home Depot. Security cameras catch him inside, using the self-checkout lane to buy a specific item, red mirror safety glasses.
To hide his eyes.
He then drives out to the massive Intel parking garage. He's wearing a disguise consisting of a yellow construction hard hat, the red mirror safety glasses, and a surgical face mask.
Completely unrecognizable.
And while in this disguise, he takes a can of spray paint and paints over the lenses of the security cameras near the specific stall where Kenny normally parks his Honda Civic.
This incident is a crucial piece of forensic evidence. During the later trial, the prosecution leaned heavily on this December 13th event to argue the element of premeditation.
This wasn't mere vandalism.
No, not at all.
Right. I was wondering about this as I read it. Why spray paint the cameras a full month in advance?
It seems like a mistake.
If Intel security team notices, they just clean the lenses or replace the cameras, and then the garage security is placed on high alert. It seems incredibly risky to flag your target zone a month early.
It was a calculated risk with a very specific intelligence gathering purpose.
What was he gathering?
It was a tactical stress test. Think of it like a hacker pinging a firewall before launching a full cyber attack.
Just seeing what happens?
Milner was actively probing the response capabilities of Intel's security apparatus. He wanted to measure the lag time. How long would it take for a security guard in the control room to notice the blinded camera feeds?
Would they dispatch a patrol immediately?
How long would the repair take? And most importantly, by blinding specific cameras, he was identifying the permanent blind spots in the garage architecture.
He was gathering real-world intelligence to map out an exfiltration route for the actual strike.
That is a staggering level of cold calculation.
It completely dismantles any claim a defense attorney could make later on that this was a crime of passion or that he went there to talk and just snapped in the heat of the moment.
Precisely. The law differentiates heavily between impulsive violence and calculated violence.
This level of cognitive focus, spending weeks acquiring disguises, purchasing untraceable vehicles under aliases, and stress-testing corporate security vulnerabilities requires deep emotional detachment and absolute, undeniable premeditation.
He was planning a murder.
Which brings us to January 27, 2023. This is the day Milner executes the plan he had been rehearsing.
The day it happened.
He returns to the Intel garage in Hillsborough. He's wearing the same construction disguise, the hard hat, the glasses, the mask.
The whole getup?
He takes a can of blue spray paint this time, and he paints over the security cameras near Kenny's spot again.
Blinding the eyes.
Then he leaves the garage, swaps vehicles, comes back in the untraceable maroon Dodge minivan, and parks directly next to Kenny's Honda Civic.
And he sits in the dark.
And he waits.
For hours.
The patience required for an ambush of that duration is significant.
Finally, at 3:21 p.m., Kenny Fandrich finishes his shift as a pipe fitter and walks into the parking structure.
The description of the security footage that the police eventually recovered is haunting. Because the cameras were coated in blue paint, the lenses couldn't capture clear details, just movement and shadows.
You see the shadow of Kenny walking toward his car.
Then there is a sudden chaotic flurry of flashing headlights.
Kenny had his car keys in his hand.
As Milner suddenly lunged from the shadows, grabbed him from behind, and violently dragged him into the open sliding door of the maroon minivan, Kenny was desperately fighting back.
He was hitting the panic button on his key fob.
The footage just shows the headlights of the Civic flashing over and over in the dim garage as he fought for his life.
The struggle inside the van was brutal and brief.
Milner applied a lethal chokehold.
The subsequent medical examiner's report characterized the specific cause of death as blunt and compressive trauma to the neck.
The physical intensity and leverage Milner applied was so severe that Kenny's neck and spinal cord were broken.
But Milner doesn't just flee the scene and leave the body in the van.
No, he doesn't. The psychology of his control obsession manifests again in the staging of the crime scene.
He has to control the narrative.
He drags Kenny's lifeless body out of the minivan and places him into the passenger seat of Kenny's own Honda Civic.
And in this incredibly macabre, deeply disturbing display, Milner takes the time to neatly arrange the scene.
He places Kenny's lunch bag, his car keys, and his cell phone right next to him on the seat.
He wanted it to look like Kenny had simply suffered a sudden, natural medical event, like a massive heart attack, right as he got to his car.
The objective behind that staging was to buy time by delaying a formal criminal investigation.
If a body in a car looks natural to a passing security guard or a beat cop, they don't immediately lock down the structure as a homicide scene.
They call an ambulance, not homicide detectives.
That assumed delay gave Milner the critical window of time he needed to exit the garage in the maroon minivan, navigate the 45-minute drive back to the Home Depot swap point, abandon the van, get back into his legitimate white Toyota SUV, and return home to his life as the gentle town vet.
But his meticulously rehearsed plan unraveled almost immediately.
Because of Tanya.
Because of the one person he was trying to control. When Kenny was late getting home, Tanya didn't just assume he was stuck in traffic. Given the 4 years of terror they had lived under, she panicked.
She knew something was wrong.
She used their shared phone location app and tracked his cell phone signal directly to the Intel garage.
She immediately called Intel Security.
Detective Stephanie Winter and Devin Rico from the local police department arrived on the scene quickly. And while the body might have looked peaceful at a glance, these are trained detectives.
They noticed things.
They immediately noticed the fresh blue spray paint dripping off the security camera lenses above the car.
That anomaly instantly escalated it from a medical call to a homicide investigation.
The detectives began pulling all the unpainted camera feeds from the surrounding areas of the garage and the street exits.
They quickly found the footage of the suspect in the disguise from the December 13th test run, and they compared it to the figure in the garage that day.
And despite the yellow hard hat, the reflective glasses, and the mask covering the lower face, the high-definition footage revealed a very distinct feature.
A prominent vertical crease on the suspect's exposed forehead.
This detail is wild. The police decide to call Milner into the station a few days later.
Just a friendly chat.
They don't tell him he's a murder suspect. They frame it as a routine check-in regarding his ongoing, pre-existing stalking charges to see if he is complying with his release conditions.
He walks into the lobby looking incredibly nervous.
And Detective Winter is sitting at the reception desk, out of uniform, acting in an undercover capacity. She observes him closely.
She notices something strange about his face.
Milner, a 57-year-old man, is wearing cosmetic makeup on his nose.
He is clumsily trying to cover up a fresh, deep scratch he received during the frantic struggle with Kenny in the minivan.
And of course, as she looks up at him, he has that exact same, highly distinct vertical forehead crease seen on the security footage.
They had their suspect and they arrested him.
But a prosecutor will tell you that having a suspect and having a conviction are two different things.
It's totally different.
To secure a first-degree murder conviction without a confession, they desperately needed to locate the primary crime scene, the interior of the maroon minivan.
That is where the murder occurred. That is where the physical evidence, the blood, hair, fibers would be.
Right. And the race to find that van is agonizing to read.
It's like a movie.
Detective Rigo manages to pull a partial VIN number from the blurry Home Depot security footage of the burner cars. He runs the VIN through the state database. He tracks the van's movement.
He discovers that after Milner abandoned it, it had been tagged as an abandoned vehicle on the side of Interstate 5.
Towed by the city and subsequently sold at auction to a massive metal scrapyard in North Portland.
Rigo gets in his cruiser and races across the city with lights and sirens blaring.
He runs into the scrapyard office, flashes his badge, gives the manager the VIN of the maroon minivan, and says they need to secure it immediately as a homicide scene.
The manager looks at the paperwork, pales, and points to a live video monitor on his desk.
It is a moment of pure, devastating investigative heartbreak.
I read this and couldn't believe it. It's a textbook chain of custody nightmare.
Detective Rigo looks at the monitor and watches the live feed of the massive industrial scrapyard claw picking up the maroon minivan and dropping it into the crusher.
He watches the primary crime scene, the physical anchor of their entire prosecution, get crushed into a solid metal cube right in front of his eyes.
I mean, from a legal standpoint, how do you win a complex murder case without the murder room? It's like trying to prove faulty wiring burned down a house, but someone has swept away all the ashes.
You lose the structural context of the crime.
It required law enforcement to execute an absolute masterclass in modern digital forensics.
The physical environment of the crime was crashed, but the invisible digital web that Milner wove while preparing for the crime proved inescapable.
Investigators brought in the FBI's specialized cellular and digital forensics teams. The critical breakthrough didn't come from the crushed van. It came from Milner's legitimate vehicle.
The FBI physically pulled the computer motherboard from the infotainment system of Milner's white Toyota SUV.
Can we break down how that actually works? What kind of data is a car storing that can solve a murder?
Modern vehicles are essentially rolling computers equipped with highly sensitive telematics control units, or TCUs.
They track everything.
They log an astonishing amount of data to operate GPS navigation, Bluetooth pairing, and safety diagnostics.
When the FBI extracted the memory chip from the Toyota's motherboard, they weren't just looking at where the car drove. They were looking at specific event data records.
The log showed the precise GPS coordinates of the Toyota SUV arriving at the Home Depot staging area.
It logged the exact second the engine was turned off and the exact second the driver's side door was opened.
Investigators then matched those exact timestamps to the Home Depot security cameras showing a man getting out of the Toyota and getting into the burner cars.
So they mathematically tied him to the burner cars, even though he bought them under a fake name.
Exactly. They used that digital anchor to stitch together a massive, continuous timeline using thousands of hours of CCTV footage from Highway Department traffic cams, the hardware store, and Intel's campus.
They proved he controlled the vehicles.
And finally, despite the devastating loss of the physical van, the forensics team made one crucial physical discovery.
During the autopsy, the medical examiner swabbed Kenny Fandrich's hands.
Underneath Kenny's fingernails from where he fought desperately against his attacker's arms in the dark, they extracted a DNA profile.
It was a perfect, astronomically undeniable match to Stephen Milner.
That brings us to the trial, which took place in January of 2025. Given the mountain of digital tracking data, the CCTV footage, and the DNA evidence, you would think he would take a plea deal.
But he didn't. Milner actually takes the witness stand in his own defense.
And the persona he adopts in the courtroom is shocking.
The sources describe him putting on this incredibly theatrical, meek, and confused act.
He is suddenly hard of hearing.
He keeps asking the prosecutor to repeat simple questions, acting like a frail, bewildered old man who couldn't possibly hurt anyone.
It is a common psychological defense mechanism for narcissists when cornered malingering or feigning incompetence to elicit sympathy.
On the stand, Milner admitted to being in the parking garage. He admitted to confronting Kenny.
But his defense was that he was attempting to conduct a lawful citizen's arrest.
He testified that he believed Kenny was going to drive drunk, and he was there to stop him, to protect the public, and save Tanya.
I need to pause and unpack this defense because it is so profoundly absurd it borders on insulting the jury's intelligence.
Let's look at the actions versus the claim.
You don't spend 3 months scouring Craigslist for burner cars, purchasing them under fake names, driving 45 minutes to a hardware store to buy a disguise, and methodically spray painting security cameras a month in advance to conduct a spontaneous Good Samaritan citizen's arrest for a potential DUI.
It's a preposterous narrative.
It is. His defense for how Kenny died was equally absurd.
He claimed the much smaller Kenny brutally attacked him, the frail older man, and that during the ensuing scuffle, Kenny tragically tripped and hit his head on the car door frame, accidentally breaking his own neck and severing his own spinal cord.
The arrogance required to present that story under oath is staggering.
And the jury saw right through the narcissism.
It only took the jury 6 hours of deliberation to return a guilty verdict on all counts, including second-degree murder and 7 counts of violating the stalking protective order.
The judge sentenced Milner to life in prison. And because of Oregon law, specifically Measure 11, he received a mandatory 25-year minimum sentence for the murder.
Measure 11 is a critical piece of the legal landscape in Oregon.
Passed by voters in the 1990s, it establishes strict, mandatory minimum sentences for violent crimes, completely removing the judge's discretion to offer leniency or early parole.
If you are convicted of Measure 11 murder, you serve 25 years day for day.
But the judge in this case went a step further.
Recognizing the profound terror of the 4-year stalking campaign, the judge took the sentences for the stalking violations and ran them consecutively, not concurrently.
That added 6 more years to the sentence, meaning Milner has to serve 31 years in a state penitentiary before he is even eligible to apply to a parole board.
For a 57-year-old man, it is functionally a terminal true life sentence.
You would think that a terminal prison sentence is where this story ends. But the legal labyrinth has one more incredibly bizarre twist.
Bringing this entire deep dive full circle to where we started.
We have to talk about the civil settlement.
Following the criminal conviction, Kenny Fandrich's estate filed a wrongful death civil lawsuit against Milner, seeking $10 million in damages.
In November 2025, the estate agreed to settle the case for $1.2 million.
The structure of that settlement is fascinating. Stephen Milner's personal estate, managed by his representatives while he was in prison, liquidated assets, likely including the cannabis farm or his veterinary practice, and paid $700,000 of that settlement.
But the remaining $500,000 was paid by a third-party corporate entity.
And when I read the name of the third party in the source file, my jaw actually dropped.
The remaining $500,000 was paid by Farmers Insurance.
The exact same insurance corporation from our first labor dispute case in Minnesota.
Let's examine this. Why on earth is a corporate insurance company paying out $500,000 to the victim of a premeditated, first-degree style ambush murder?
It is a stunning display of high-level civil litigation strategy exploiting a very specific legal loophole regarding insurance liability.
To understand this, we have to look at how insurance contracts are written.
Standard insurance policies, whether we are talking about a personal umbrella liability policy Milner held or a business liability policy tied to his veterinary clinic, contain strict exclusionary clauses.
They explicitly exclude coverage for intentional criminal acts.
The logic is simple. You cannot buy a policy that indemnifies you against committing murder.
Which is obvious. You can't buy murder insurance.
If you intentionally kill someone, your insurance company has zero legal duty to pay out a wrongful death claim on your behalf.
So if the policy excludes intentional murder, and he was convicted of intentional murder, how did Kenny's lawyers maneuver Farmers Insurance into paying $500,000?
By strategically focusing on the timeline of the abuse rather than just the final act of violence.
The plaintiff's lawyers were incredibly savvy.
They likely framed the civil claim not exclusively around the intentional murder in the parking garage, but around the 4 years of negligent stalking, invasion of privacy, and severe emotional distress that preceded the homicide.
They argued that Milner's prolonged, reckless, negligent behavior prior to the murder triggered the liability coverage.
They separated the negligent stalker from the intentional murderer in the eyes of the civil claim.
That is brilliant. They're saying, ignore the murder for a second. Your client negligently terrorized this family for 4 years, and that negligence caused $10 million worth of emotional damage.
Exactly. And this forces the insurance company into a complex actuarial calculation.
The insurance company has a legal duty to defend its policyholder against claims of negligence.
If Farmers Insurance refused to settle and took the case to a civil jury trial, they risked jury hearing about 4 years of horrific psychological abuse and handing down a massive $10 million verdict based solely on the negligence claims.
Faced with that massive financial exposure, the insurance company's actuaries ran the math.
They decided it was significantly cheaper to settle the negligence portion of the lawsuit for a guaranteed $500,000 just to make the case go away, rather than risk a runaway jury verdict.
Well, it is a masterclass in using the cold mechanics of the law, the definitions of negligence versus intent, the fear of jury verdicts, the actuarial math to force a financial outcome from a corporation that had no desire to pay.
So as we bring this deep dive to a close, let's look at the massive territory we've covered.
We started with Gary Milner and Farmers Insurance in a sterile Minnesota courtroom, fighting over the technical definitions of exempt labor, missing scantrons, and the burden of proving unpaid overtime to a jury that awarded them $0.
And we ended with Stephen Milner and Farmers Insurance in a cold Oregon parking garage, dealing with the devastating aftermath of a lethal obsession, crushed minivans, and a grieving widow using the threat of a civil jury to force an insurance payout.
Both of these cases, despite being factually miles apart, highlight the staggering, almost incomprehensible breadth of our justice system.
It is a massive, complex machine tasked with doing everything from organizing corporate overtime metrics to hunting down millionaire murderers using automotive motherboards.
Yet in both realms, whether civil or criminal, the system frequently demands that the victims, whether they're unpaid workers stripped of their legal fees by an appellate court, or terrified spouses clutching worthless pieces of paper while waiting for the police to act, carry the heaviest burden.
It requires the vulnerable to prove their suffering with missing time cards and digital GPS trackers.
It requires us to deeply question how much true proactive protection the law actually offers when it encounters the sheer irrationality of human nature, the financial power of a corporation, or the immense wealth of a determined stalker.
Which leaves you, the listener, with this final thought to mull over as we sign off.
We rely on the law to organize our society. We rely on it to keep us safe. We trust the precision of the machine, believing that if we follow the rules will protect us.
But the law is fundamentally just a set of written codes, interpreted and enforced by flawed, biased humans.
If a judge's signature on a piece of paper can't stop a stalker in a bulldozer, and winning a 10-day jury verdict against a corporation doesn't guarantee you a single dime of restitution, how much of our justice system provides actual tangible protection? And how much of it is just the comforting illusion of a security camera telling us exactly what we want to see, right up until someone covers the lens with paint?